So, have you ever just been, completely stonewalled by a massive company?
Oh, yeah, constantly.
Right. Like you buy something and it breaks immediately. Or maybe it's even dangerously defective.
And then you try to get help, and it's just a nightmare.
Exactly. You call customer service and you're transferred to some automated machine, then finally to a representative who is, just reading from a script.
Yep, the classic script.
And then they inevitably point you to some 50-page terms of service document, the one you never read but supposedly agreed to.
The one nobody reads. I mean, let's be honest.
Right, and you're just left there with a broken product, an empty wallet, and this overwhelming feeling of just absolute powerlessness against a corporate giant.
It is honestly a universal modern frustration. I mean, we've
Yeah.
built this incredibly complex global economy, but the individual buyer often feels like, you know, just a microscopic gear in a very indifferent machine.
Yeah,
You're
totally.
just expected to take the loss and move on.
But what if you didn't have to? I mean, what if you actually had a very specific, highly calibrated legal arsenal to fight back and win?
That is exactly what we're getting into.
Because today, we are taking a unique approach. We got our hands on the curriculum for a really prestigious law masterclass at Osmania University.
Specifically, Unit V of their syllabus.
Right, which focuses entirely on the Consumer Protection Act of 2019. And look, don't let the phrase university syllabus scare you off here.
No, no, it's not going to be dry.
Not at all. We are not here to just read a textbook or make you memorize section numbers. We are using this curriculum as a map, essentially.
A map to decode the exact legal leverage you actually have in the digital age.
Exactly. And that map is essential, right? Because the 2019 Consumer Protection Act, it fundamentally rewrote the rules of engagement.
Oh, completely. I mean, the previous law was from 1986.
1986.
Yeah, think about the world back then. E-commerce wasn't even a concept.
Right. Nobody was buying groceries on their phone.
Exactly. Social media influencers hawking diet pills just didn't exist. Multi-level marketing on Instagram wasn't a thing.
So the law had to be radically transformed.
It did. It had to address the way we actually buy and sell today.
So we're going to explore that transformation in this deep dive. We'll look at who actually qualifies for this protection, because the line between a personal purchase and a commercial one is, well, it's blurrier than you might think.
Very blurry.
We'll also examine the actual remedies, like how courts calculate the real-world value of a loss over time.
That part is fascinating.
It really is. And we're going to venture into the criminal side of corporate negligence, including some truly severe penalties for bad actors.
Things that will legitimately surprise people.
Yeah. And eventually, we're going to tackle this massive philosophical debate from the syllabus, the razor-thin boundary between a tragic human error and a criminal act, particularly in the medical field.
Right, the Jacob Matthew case.
Exactly. So, let's start right at the threshold. Before you can demand justice, you have to prove you actually belong in the room. The law has a very specific definition of who gets to wear the armor of a consumer.
Yeah, and the defining line here is intent and usage.
Okay, break that down for me.
So a consumer is basically anyone who buys goods or avails of a service for a consideration, meaning, money changes hands or is promised to change hands.
Simple enough.
But the critical exclusion, and this is huge, is the commercial purpose.
Ah.
If you buy a product to resell it or to use it as the primary engine of a large-scale commercial enterprise, you are not a consumer under this specific act.
You're just a business at that point.
Exactly. You are a business,
Yeah.
and you have to rely on standard contract law, which is, frankly, a much colder, more adversarial arena.
Okay, let me test the boundaries of that, because commercial purpose sounds like it could be a massive loophole for companies to just deny coverage.
It definitely gets tested.
Right, so let's say I buy this expensive, high-end sewing machine. I use it to hem my own clothes, but, I also occasionally take small commissions from friends to tailor their dresses, just to make a little extra cash.
Okay, a side hustle.
Yeah. If that machine catches fire due to a defect, is the manufacturer going to point at me and say, you made money with it, you're a commercial entity, claim denied?
Well, that is exactly the kind of friction courts deal with constantly. But the Indian legal system has actually developed a very nuanced interpretation here.
Really? How so?
It largely revolves around the concept of self-employment and earning a livelihood. If you were using that sewing machine primarily to earn your livelihood by means of self-employment, you are still protected as a consumer.
Oh, wow.
Yeah, the law recognizes the independent gig worker, the solitary artisan or the taxi driver who just owns one car.
So the scale of the operation actually matters.
Immensely. I mean, if you buy 50 sewing machines, rent out a warehouse, and hire 20 people to make shirts, well, you've crossed the Rubicon into commercial enterprise.
Yeah, you're a factory at that point.
Exactly. You are no longer the vulnerable individual that the Consumer Protection Act was designed to shield. You have the resources to hire corporate lawyers. The Act wants to protect the person who doesn't.
That makes a lot of sense. It protects the little guy without subsidizing massive corporate disputes.
Exactly.
But looking at the Osmania materials, the biggest leap forward really seems to be how the law defines the transaction itself.
Oh, without a doubt.
Because the 1986 law was written for brick-and-mortar stores. You walk in, you hand over cash, you take a paper receipt.
Which left a massive gaping hole as the internet emerged.
I can imagine.
For years, digital platforms tried to argue that they were just intermediaries, or that, clicking a button on a website wasn't the same as signing a legally binding purchase agreement.
Just dodging responsibility entirely.
Constantly. But the 2019 Act crushed that ambiguity. The definition of buying goods and hiring services now explicitly includes all online transactions, teleshopping, direct selling, and multi-level marketing.
Wait, I want to pause on multi-level marketing and direct selling because that is a notorious gray area.
Oh, that's a huge problem area.
People get dragged into these WhatsApp groups or Instagram circles, and they're pressured into buying bulk inventory of health supplements or beauty products.
With the promise of becoming entrepreneurs.
Yeah, exactly. And when the bottom falls out and the products turn out to be defective or just totally unsellable, the parent company usually just vanishes.
Yep. Historically, those parent companies would argue that the people selling the products were independent contractors, not consumers.
So the company would say they had zero liability.
Precisely. But by explicitly bringing direct selling and multi-level marketing under the consumer protection umbrella, the law is finally piercing that corporate veil.
That's amazing.
It acknowledges the actual power dynamics at play.
So assuming you do meet the definition, how do you actually fight back? Because the stereotypical image of navigating the legal system, really anywhere, but especially in India, is not exactly user-friendly.
It's usually a nightmare of paperwork.
Right. You picture endless stacks of paper, trying to find a file, and traveling to whichever massive city the corporation happens to be headquartered in.
Well, the jurisdiction rules used to be a massive deterrent.
How bad was it?
If you lived in a rural area and ordered a defective laptop from a mega corporation headquartered in Mumbai, the old rules often meant you had to file the dispute in Mumbai.
You've got to be kidding me.
No. And for a 50,000 rupee laptop, the cost of travel and lodging for a trial completely negated the value of the remedy.
So it's just a calculated attrition strategy by the corporations. Make the process so inconvenient that the consumer just gives up.
The legal equivalent of being put on hold for 4 hours.
Wow. That is infuriating.
It was. But the 2019 Act flipped the script regarding territorial jurisdiction. Now, you can institute a complaint where you, the complainant, reside or personally work for gain.
Oh, so you bring the fight to your own backyard.
Exactly. You bring it to them.
That is a massive shift in leverage for the consumer.
It truly is. And to manage this, the system is actually divided into 3 tiers based on the financial value of your grievance. They call it pecuniary jurisdiction.
Okay, how does that break down?
You start at the district commission for claims up to 1 crore rupees.
1 crore. That's 10 million rupees, which realistically, that covers almost every standard consumer disaster you can think of.
Basically, yeah.
A botched home renovation, a defective car, even significant medical billing fraud.
Most people will never need to look beyond the district level. But if the value is between 1 crore and 10 crore, you go to the state commission.
Okay.
And for anything exceeding 10 crore, the National Commission takes original jurisdiction.
So it's basically a filter.
Exactly. It prevents the highest courts from being choked with disputes over broken microwaves while ensuring that multi-million-dollar class action failures get the heavy judicial scrutiny they actually require.
And the filing process itself has been modernized too, hasn't it? The syllabus highlights something called the eDockil portal.
Yes, eDockil is incredible. It's the digital infrastructure built specifically to support this new law. It allows you to file your complaint, upload your documentary evidence, and even pay the nominal fees entirely online.
No going to a courthouse?
No. And furthermore, the Act explicitly allows for hearings to be conducted via video conferencing.
So hypothetically, I could be sitting in my living room in a small town in Kerala, logging onto a portal and facing down the legal team of a massive multinational tech company without ever putting on a suit or paying for a flight.
That is the exact legislative intent. democratized, frictionless access to justice.
But I have to play devil's advocate here for a second. Access is great, but speed is another thing entirely.
Fair point.
The Indian judicial system is, well, legendary for its backlog. Cases can drag on for decades. Does the Consumer Protection Act actually force a speedy resolution, or is a consumer still looking at years of litigation?
The statute actually mandates a strict timeline. Once a complaint is admitted, the commission is supposed to decide the matter within 3 months.
3 months? That's really fast.
It is. And if the dispute requires sending a product to a laboratory for testing, say an adulterated food sample or a complex electronic component, that timeline extends to 5 months.
3 to 5 months. But is that actually happening on the ground?
It's a mixed bag, honestly. The law provides the mandate, but commissions are often understaffed. However, the timelines do create a statutory right to a speedy trial that judges take very seriously.
So it puts pressure on the system.
Yes. And to alleviate that backlog, the 2019 Act introduced something entirely new to this framework, which is mandatory consideration of mediation.
Mediation. So before we even get to a judge banging a gavel, there's a detour.
A highly structured detour. Chapter 5 of the Act established consumer mediation cells attached to every single commission.
How does that work in practice?
When the dispute is first heard, if the judge looks at the facts and thinks, you know what, this isn't a complex point of law, this is just a stubborn disagreement over a refund, they can refer the parties directly to mediation.
But why would a massive company agree to mediation? Don't they want to use their expensive lawyers to grind the consumer down over time?
Not always. Litigation is expensive for them too, and it creates public records.
PR problems.
Exactly. If a company knows they sold a bad batch of televisions, fighting 100 separate trials across the country is an administrative nightmare and a massive PR disaster.
So they want to keep it quiet.
Right. Mediation is confidential.
Hmm.
A trained independent mediator gets both sides in a room or on a video call and essentially says, look, we can spend 6 months fighting, or the company can offer a replacement and a 20% refund right now, and we all go home.
Wow. It's risk management for the company and guaranteed immediate relief for the consumer.
And if it fails, you lose nothing. The case goes right back into the standard adjudicatory pipeline. It's really a mechanism designed to drain the swamp of easily resolvable disputes so the judges can focus on the complex bad faith actors.
Okay, so let's assume mediation doesn't work. The company just stubbornly refuses to budge. You go to trial, you present your evidence via video link, and the judge actually agrees with you.
You win your case.
Right. You've proven a deficiency in service or a defective product. We finally arrive at the payoff. What can the commission actually force the company to do?
Well, the menu of reliefs is extensive and incredibly potent. Naturally, they can order the standard remedies, like removing the defect, replacing the goods with a new defect-free equivalent, or simply refunding the purchase price with interest.
Right, that's standard making the victim whole territory, just fixing the immediate problem.
But it goes much further than that. The commission can order compensation for any loss or injury suffered due to the company's negligence.
No.
They can order the absolute discontinuation of an unfair trade practice. If a product is dangerous, they can order it withdrawn from the market entirely and demand the company cease manufacturing it.
But the syllabus highlights a specific power that seems to cross a line from just fixing a mistake into actual retaliation. I'm talking about punitive damages.
Yes, this is major. The commission has the power to grant punitive damages in circumstances it deems fit.
Explain the philosophy behind that to me, because if I buy a toaster for, say, 2,000 rupees and it catches fire and burns my kitchen counter, compensation covers the toaster and the counter. Why does the court need to punish the company beyond that?
Because if the penalty for selling a dangerous toaster is only ever replacing the toaster and the counter, the corporation simply builds that cost into their spreadsheet.
Oh, I see.
It just becomes a cost of doing business. If it's cheaper to pay out a few settlements than to halt the assembly line and redesign the heating element, a profit-driven entity will just keep selling the dangerous toaster.
Right. It's the famous Ford Pinto calculation. It's cheaper to let a few cars explode and pay off the victims' families than to recall all the cars and fix the gas tank.
Exactly. It's cold corporate math. Punitive damages exist to shatter that spreadsheet logic. It allows the commission to look at a company and say, your behavior wasn't just negligent, it was egregious, reckless, and in bad faith. So we are going to fine you an amount completely disconnected from the consumer's actual loss.
An amount that actually hurts.
Yes, an amount so severe that it actively damages your quarterly earnings. We are going to make it financially terrifying for you to ever ignore a safety defect again.
That is profound. It shifts the burden of fear completely from the consumer to the corporation.
It turns the Consumer Commission into an instrument of active market regulation.
But it's not just physical defects that cause harm. The syllabus dives into something called unfair contracts, which is a massive new addition for 2019, right?
This might be the most revolutionary aspect of the new law, honestly. For decades, companies relied on the sanctity of the contract. If you signed a document or clicked "I agree" on a digital form, courts were generally very reluctant to intervene.
Because the assumption was that two free parties made an agreement. But we know that's a fiction. Nobody reads a 50-page end-user license agreement before updating their phone's operating system.
Nobody.
And even if you did read it and didn't like a specific clause, you can't negotiate with Apple or Google. It's a take-it-or-leave-it proposition.
And the legal term for that is an adhesion contract, or a click-wrap agreement.
Click-wrap. Yeah.
The 2019 Act finally recognized the inherent imbalance of power in these situations. It explicitly defines an unfair contract and gives the state and national commissions the power to declare specific clauses completely null and void, even if you signed it.
Wait, what actually makes a contract legally unfair?
The law lists specific hallmarks of abuse. For instance, requiring manifestly excessive security deposits.
Like what?
Imagine a utility company demanding a deposit equal to 3 years of projected bills just to turn on your water.
Or imposing disproportionate penalties. I've seen contracts for gym memberships or internet service where if you try to break the contract a month early, they charge you triple the remaining balance as a cancellation fee.
Exactly. And the commission can now look at that fee, determine it has absolutely no relation to the company's actual financial loss, and just strike it down.
That is so empowering.
Another massive target is unilateral termination without reasonable cause.
The classic, we reserve the right to terminate your account at any time for any reason clause.
Right. Digital service providers lean on that heavily. They ban an account, withholding access to digital purchases or funds, and just hide behind the terms of service.
So what happens now under the CPA?
Under this act, a consumer can argue that such a clause is fundamentally abusive, and the commission can force the company to justify the termination or restore the service. The law is basically saying that you cannot legally consent to your own exploitation just because it was buried in page 42 of a digital document.
I love that phrase. You cannot consent to your own exploitation. To ground this in reality, the Osmania materials highlight a really landmark case, Vinacana v. Ansel Properties.
Oh, that's a brilliant case.
Yeah, it perfectly illustrates how these remedies, especially compensation, have to adapt to real-world economics.
The Vinacana case is a masterclass in equitable relief, particularly in the notoriously volatile real estate sector. The facts are straightforward, but pretty devastating.
Set the scene for us.
So the consumer, Vinacana, entered into an agreement to purchase a flat from a builder. She paid her deposits. The builder promised to deliver possession of the constructed flat by June 1st, 1999.
Let me guess. June 1999 comes and goes, and there's no flat.
No flat at all. The builder delayed and delayed. Eventually, frustrated, the consumer demanded a full refund of her deposited amount, along with an 18% interest rate to compensate for the years her money was just locked up.
And the builder refused.
The builder refused. The dispute winds its way all the way up to the National Commission.
Now, from a purely mathematical standpoint, returning the deposit plus 18% interest sounds like a reasonable remedy. You give the money back, you add a penalty rate, everyone walks away.
And that's exactly how a strict old-school contract court might view it. But the National Commission looked at the macroeconomic reality of the situation. The dispute was being decided years after the promised delivery date. What happens to the real estate market over 5 or 6 years?
It explodes. The price of property skyrockets.
Exactly. The commission realized that if they just gave Vinacana her original money back, even with that 18% interest, she was actually being punished.
How so?
Because that return sum could no longer buy an equivalent flat in that same locality in the current market. The builder's delay effectively priced her completely out of the neighborhood.
Oh, wow. So the builder fails to do their job, hold on to her money, property values double, and the builder gets to sell that delayed flat at the new higher market rate to someone else.
Yes.
While the original consumer is left with a refund that has lost half its purchasing power.
That was the exact injustice the National Commission recognized. They ruled that simply refunding the money was totally inadequate.
So what did they order?
They established that it is the primary duty of the builder to deliver possession of the promised flat. If that specific flat is unavailable, they must provide a flat of equivalent size.
Okay.
And if they cannot do either, they must pay compensation calculated not on the original deposit, but adequate to enable the consumer to purchase a new flat of the same size at the prevailing market rate.
That is brilliant. It forces the court to look out the window, observe what the real world actually costs day, and adjust the penalty accordingly.
Yes, it prevents the company from profiting off their own delay.
It perfectly illustrates the difference between static law and equitable law. The consumer forums are designed to be equitable, to ensure the outcome is actually fair in practice, not just mathematically sound on paper.
That's the heart of the CPA.
But let's look at the flip side for a moment. Let's say a district commission makes a ruling, and the company, or even the consumer, looks at it and says, this judge is completely out of line. This is an unfair interpretation.
It happens all the time.
Right. We have to talk about the appellate structure. How do you actually challenge a ruling?
The law built in a very rigid, hierarchical ladder of escalation to catch those errors. But the most important element of this ladder is the clock. The fundamental principle governing appeals in consumer law is the 30-day rule.
Walk me through that ladder.
Okay, so if you get an unfavorable order from a district commission, Section 41 dictates that you have exactly 30 days from the date of the order to file an appeal with the state commission.
Got it.
If the state commission rules against you, Section 51 gives you 30 days to appeal to the national commission.
Okay.
And finally, if the national commission hands down an original order you disagree with, Section 67 allows you a final 30-day window to take the fight directly to the Supreme Court of India.
30 days is an incredibly tight window. I mean, by the time the order is mailed to you, you consult your lawyer, review the ruling, draft a comprehensive appeal, and actually file the paperwork. The month is practically over. Why is such a punishing timeline?
Because the entire purpose of the Consumer Protection Act is speedy resolution. If you give parties a year to file an appeal, the corporate strategy will always be to wait 364 days to file, just to bleed the consumer's patience and finances dry.
Oh, of course.
The 30-day rule forces immediate action and prioritizes finality.
But what if disaster strikes? Let's say I lose at the district level, and on day 5, I'm in a severe car accident and hospitalized for 2 months. When I wake up, the 30-day window is closed. Am I just out of luck because of a tragedy?
The law isn't entirely heartless, thankfully. The Act contains a caveat. The appellate commission can entertain an appeal after the 30-day expiry if the appellant proves they had sufficient cause for the delay.
How does a court define sufficient cause? Because I imagine every corporate lawyer tries to claim their dog ate the filing paperwork.
They absolutely try, and courts are deeply skeptical. Sufficient cause is not defined by a specific list of acceptable excuses. It's heavily dependent on the facts.
So like the car accident.
Right. Being hospitalized in a coma. Undoubtedly sufficient cause. A massive postal strike that paralyzes the region's mail system. Likely sufficient cause.
What about a lazy lawyer?
No. Your lawyer's simply forgetting the deadline. Or an internal corporate delay where a file just sat on a manager's desk for 3 weeks. The courts will reject that instantly. The delay must be due to circumstances genuinely beyond the control of the party acting in good faith.
Makes sense. But appeals aren't the only way a higher court can get involved. The syllabus mentions something called revisional jurisdiction. I hear this term thrown around in procedural dramas sometimes. What is the actual difference between an appeal and a revision?
It's a great question. An appeal is essentially an argument over the facts or the interpretation of the law. You go to the higher court and say, the judge weighed the evidence incorrectly, or the judge misunderstood the definition of an unfair contract.
You want the higher court to re-examine the meat of the case.
Exactly. Revisional jurisdiction is entirely different. It has absolutely nothing to do with whether the outcome was fair. It is about policing the structural authority of the lower courts.
Give me an example of when a court would use revisional jurisdiction.
Sure. So under Sections 47 and 58, the state and national commissions can call for the records of a lower commission if there is an issue of jurisdiction or material irregularity. Let's say you file a complaint about a 15 crore rupee medical malpractice claim at the district commission.
But wait, earlier you said the district commission is only allowed to hear cases up to 1 crore?
Exactly. If the district commission ignores that rule, holds a trial anyway, and issues an order, the opposing party doesn't file a standard appeal arguing the facts of the malpractice.
They just attack the court's authority.
Right. They file a revision petition to the state commission saying the district commission exercised a jurisdiction not vested in it by law.
And then what?
The higher court will immediately quash the order. They won't even look at the evidence of the malpractice. They will just annul the ruling because the lower judge had no legal authority to make it. Revisional power basically ensures the courts stay in their designated lanes.
Okay, so assuming a case navigates the district court, survives any appeals, and the 30-day windows finally close, what stops a massive corporation from just saying, you know what, we don't like this consumer forum. We're going to take this exact same dispute and file a brand new lawsuit in a regular civil court and start the whole circus over again?
The doctrine of finality. Section 24 of the Act explicitly declares that every order of a commission shall be final if no appeal has been preferred.
Oh, so you can't just try again somewhere else?
No. You cannot forum shop. You cannot try to get a second bite at the apple in a different courtroom. This is rooted in the legal principle of res judicata, meaning the matter has been judged.
And how is that final order actually enforced? I mean, a consumer commission isn't a traditional court with bailiffs and police attached to it. Does their order carry actual weight?
Absolutely it does. Section 71 elevates these commissions. It states that every order made by a commission shall be enforced in the exact same manner as if it were a decree made by a regular civil court.
So what happens if a company just ignores the order to pay?
If a company refuses to pay the ordered compensation, the consumer can initiate execution proceedings. The authorities can actually attach the company's property, seize their bank accounts, and physically force compliance.
Wow.
The order is not a polite suggestion. It is a legally binding decree.
That brings a lot of peace of mind for the civil side of things. If you are wronged, you can be made whole. But up to this point, we've mostly been discussing negligence, broken contracts, or delays. We are basically talking about businesses making mistakes.
Right. Careless errors.
We need to pivot to the dark side. What happens when a business isn't just clumsy, but actively deceptive, predatory, or dangerously reckless?
This is where the 2019 Act shows its true regulatory muscle. The drafters realized that relying solely on individual consumers to file civil lawsuits isn't enough to protect the public from systemic scams or hazardous goods.
Yeah, if a company is selling toxic cough syrup, we can't wait for 50 people to get sick and file individual complaints. We need proactive policing.
Enter the Central Consumer Protection Authority, the CCPA.
Okay, tell me about the CCPA.
Established under Chapter 3, the CCPA is a monumental shift from reactive justice to proactive regulation. Their statutory mandate is to protect, promote, and enforce the rights of consumers as a class.
Meaning they don't need a specific victim to knock on their door to start an investigation?
Exactly. They have a dedicated investigation wing. If they notice a trend of predatory behavior, say an airline systematically denying legally mandated refunds, they can initiate an inquiry suo motu, which means on their own motion.
And if they find a violation?
Their powers are sweeping. They can order mass recalls of dangerous goods, mandate the reimbursement of prices to thousands of consumers at once, and force companies to issue public apologies.
But beyond civil recalls, the syllabus dives into Chapter 7, offenses and penalties. And looking at these notes, we aren't talking about slaps on the wrist or minor fines here. We are talking about severe criminal liability, prison time.
Yes, criminal liability.
Let's start with something that bombards us every single day: misleading advertisements.
Advertising is the lifeblood of commerce, but when it crosses the line into deception, it manipulates the market and genuinely harms consumers. Under Section 89, if a manufacturer or service provider promotes a false or misleading advertisement that is prejudicial to the interests of consumers, they face imprisonment for a term which may extend to 2 years and a fine up to 10 lakh rupees.
2 years in prison for a commercial, that is intense. But the line between a misleading ad and standard marketing exaggeration can be really thin, right? Every pizza place claims to have the best pizza in the world. They aren't going to jail for that.
No, they aren't. And that's a crucial distinction in law known as puffery.
Puffery.
Yeah, the courts expect a reasonable consumer to understand that subjective claims, the tastiest, the most refreshing, are just marketing fluff. You can't empirically prove or disprove them. But a misleading advertisement makes a specific factual claim that alters the consumer's purchasing decision based on a lie.
The Osmania materials bring up a really fascinating case study on this exact boundary. Horlicks Ltd. Zytus Wellness.
Oh, the Horlicks case is a brilliant exploration of how courts view electronic advertising. Horlicks and Zytus are massive competitors in the nutritional health drink market. Zytus aired a television commercial that didn't just promote its own product, it actively disparaged Horlicks.
I'm so.
It presented visuals and claims that strongly implied the competitor's drink was nutritionally inferior and a poor choice for children.
And I imagine Horlicks didn't just sit back and take the hit.
Not at all. They immediately sought an injunction. The Delhi High Court had to analyze the psychological impact of the medium itself. They noted that print ads can be read carefully, analyzed, and dismissed. But electronic media television commercials, pre-roll video ads, leave an indelible mark on the viewer's mind. They are brief, visual, and highly emotionally manipulative.
Right. If a parent sees a commercial implying a specific drink will make their child healthier than the competitor, that parent is going to act on that fear and hope.
Exactly. The court ruled that while you can puff up your own product, you cannot disparage a rival's product without concrete, objective, scientific proofs. Deliberately broadcasting unverified claims that damage a competitor and mislead the public is not free speech. It is a deceptive trade practice.
Wow.
The CCPA now has the teeth to crack down on exactly this kind of behavior, basically protecting the mental landscape of the consumer.
But psychological manipulation is one thing. Physical harm is another entirely. Section 90 deals with adulterants. And the escalating scale of punishment here is, frankly, terrifying.
It is. An adulterant is any extraneous matter added to a product that compromises its safety or quality. Think of industrial chemicals mixed into cooking oil or chalk powder in infant formula.
Horrifying.
Because the potential for mass harm is so vast, the law establishes a strict, escalating scale of criminal liability based entirely on the outcome of the adulteration.
Let's walk through that scale because it shows how the law quantifies bodily harm. The lowest rung is if the adulterated product does not result in any injury. Like the consumer buys the tainted oil, maybe notices it smells funny, and throws it out. No one gets hurt.
Even in that scenario of zero harm, the manufacturer still faces up to 6 months in jail and a fine of up to 1 lakh rupees. The law penalizes the creation of the hazard, regardless of whether they got lucky and avoided a tragedy.
Now, what if the product is consumed and causes injury not amounting to grievous hurt? Say, a severe bout of food poisoning that requires a hospital trip but causes no permanent damage?
The penalty jumps. Imprisonment up to 1 year, fine up to 3 lakh rupees.
Then we reach grievous hurt. This means permanent, severe damage, loss of sight, organ damage, long-term debilitation.
For this, the manufacturer faces up to 7 years in prison and a fine up to 5 lakh rupees.
And the final tier, if the adulterated product results in the death of a consumer.
The imprisonment shall be not less than 7 years and may extend to life imprisonment, along with a fine of not less than 10 lakh rupees.
Life imprisonment for selling tainted goods. We are treating corporate negligence with the same severity as premeditated murder.
In the eyes of the law, when you release a poisonous product into the mass market, the indifference to human life is so profound that it warrants the ultimate penalty. And Section 91 mirrors these exact punishments for the manufacture and sale of spurious goods, meaning dangerous counterfeit products designed to deceive the buyer.
But let me bring this back to reality for a second. The law on paper is terrifying. Life imprisonment, massive fines. But a skeptic would argue, how often does a CEO actually go to prison for life because a factory manager watered down the milk? Are these penal sanctions actually effective, or are they just legislative theater?
That is the perennial friction between enactment and enforcement. The drafters knew that white-collar criminals often evade standard criminal proceedings through endless delays and bail appeals. To combat this, the 2019 Act includes specific procedural hammers. First, offenses involving grievous hurt or death under these sections are classified as cognizable and non-bailable.
Wait, non-bailable, meaning you can't just have your corporate lawyers write a check to keep you out of a cell while the trial drags on for 5 years.
Precisely. The police can arrest the perpetrators without waiting for a magistrate's warrant, and getting bail is exceptionally difficult. It immediately removes the bad actors from society and shuts down the operation.
That's a serious threat.
Furthermore, the court has the power to strike at the lifeblood of the business, its operating licenses. On a first conviction, the court can suspend the business license for up to 2 years. On subsequent convictions, they cancel the license entirely. The corporate entity ceases to legally exist.
That is a massive deterrent. But the syllabus also mentions Section 96, compounding of offenses. This seems to apply to the lesser infractions, like certain misleading ads or failing to comply with a CCPA order. What does that mean?
Compounding is a fascinating legal mechanism. It essentially allows the offender to pay a prescribed sum of money to the authorities to settle the criminal charge without going through a full, protracted public trial.
I have to push back on that. Isn't compounding just a sanitized word for a legal bribe?
Yeah.
The state says, you broke the law, but if you write us a big enough check, we'll look the other way. Doesn't that just turn lawbreaking into a recurring subscription fee for wealthy corporations?
It's a very valid criticism, and it's exactly why compounding is highly regulated. You cannot compound an offense involving grievous hurt or death. You cannot compound an offense if a formal criminal complaint has already been instituted by a court. And crucially, to prevent that exact subscription fee abuse, the law explicitly states you cannot compound the same or similar offense within 3 years of the first instance.
Ah. So it's a one-time get-out-of-jail card for a first-time non-lethal mistake.
Exactly. It recognizes the reality of the judicial system. If the CCPA dragged every single company that published a slightly misleading flyer into a 5-year criminal trial, the courts would collapse.
They wouldn't be able to handle it.
Right. Compounding creates a pragmatic, immediate revenue stream for the state, guarantees immediate compliance from the offender, and clears the docket. But if the company does it again within 3 years, the hammer drops and they go to trial. It's a calibrated release valve.
Okay, so we've established that the state has immense power, and individual consumers have a streamlined, powerful system to demand massive compensation. Which brings us to the inevitable counterweight. We need to talk about vexatious complaints and the protection of good faith.
A very important topic.
If I have all this power as a consumer, what stops me from weaponizing it? What stops a malicious customer from harassing a local bakery with baseless lawsuits just to extort a settlement?
A functional legal system must balance the scales. The law cannot simply become an instrument of extortion against legitimate businesses. The Act builds in safeguards, starting with the authorities themselves. Section 93 deals with something called vexatious search.
Meaning a search that is annoying, frustrating, or lacking any real grounds.
Yes. The Director General of the CCPA has vast powers to enter premises, search warehouses, and seize documents. But if an officer conducts a search or seizes records knowing that there are no reasonable grounds for doing so, perhaps acting on a personal vendetta or taking a bribe from a competitor, that officer themselves faces up to 1 year in prison or a 10,000 rupee fine. The law explicitly polices the police.
That's good to hear. But what about the consumers? The e-Kill portal makes it cheap and easy to file. What happens when someone spills hot tea on their lap and tries to sue the cafe for 5 crore rupees?
The Consumer Protection Act lowers the barrier to entry, but it does not lower the burden of proof. The complainant must still provide documentary evidence and logically prove that a defect exists or that the service was legally deficient. A feeling of dissatisfaction is not a legal deficiency.
The syllabus provides a perfect case study for this boundary. Sapient Corporation employs Provident Fund Trust v. HDFC Bank.
Oh, this case is vital for understanding that consumers don't automatically win just because they are unhappy. The complainant, the Sapient Trust, held accounts with HDFC Bank. There was a dispute over how the bank debited their account and handled certain funds. The trust claimed this was a severe deficiency in service and dragged the bank to the consumer forum.
But the bank wasn't just acting maliciously or losing the money, right? They were following the rules.
Exactly. The court examined the facts and realized that HDFC Bank was strictly adhering to the explicit directions and guidelines laid down by the regulatory authorities, in this case, the Reserve Bank of India.
So the bank is essentially saying, we can't provide the service you want because the federal government legally forbids us from doing so.
And the court agreed entirely. The ruling established a firm precedent. A behavior that strictly conforms to the direction of a regulatory authority cannot be labeled as negligence or a deficiency in service. The consumer's arguments were dismissed as baseless. You cannot successfully sue a business for failing to meet your expectations if meeting those expectations would require the business to break the law.
But let's take it a step further. Let's say I own a popular restaurant. A disgruntled customer, completely in bad faith, files a consumer complaint claiming my kitchen is infested with rats and my food is adulterated. It makes the local news. 6 months later, the court dismisses the claim as entirely false. Can I, the restaurant owner, sue that consumer for defamation? They use the legal system to destroy my reputation.
This ventures into the intersection of consumer law and tort law, which is a crucial area of study. The general principle is that every citizen has a fundamental democratic right to approach a competent legal authority and air a grievance. Merely filing a complaint, even a highly damaging one, does not per se amount to defamatory imputation.
So the system protects the whistleblower, even if they are wrong.
To a point. The legal process is privileged. You cannot be sued for defamation simply for making an allegation in a courtroom. However, this protection is not absolute. If the competent court explicitly rules that the complaint was not just unproven but entirely maliciously false, a deliberate fabrication designed to harass, the shield falls.
Ah, okay.
Once the consumer forum dismisses the vexatious claim, the business can initiate a separate civil suit for malicious prosecution or defamation, seeking damages for the harm caused to their reputation. The system protects good faith reporting, but it punishes the deliberate weaponization of the judicial process.
Which perfectly transitions us into the final and perhaps most complex section of our dive into this syllabus: remedies under other laws and the razor-thin line between a tort and a crime. Because as comprehensive as the Consumer Protection Act is, it doesn't exist in a vacuum. A consumer transaction can easily bleed into broader societal law.
Absolutely. The CPA is a highly specialized tool for buyer-seller disputes. But sometimes a corporate failure is so massive, it transcends a simple deficiency in service. The syllabus touches on public interest litigation, or PIL.
Right. A PIL is a mechanism where any concerned citizen or organization can move the High Court or Supreme Court on behalf of an unrepresented or marginalized group.
Exactly.
If a pharmaceutical company releases a drug that causes widespread birth defects across rural communities, you don't file 10,000 individual CPA complaints for a refund. You file a PIL because it is a massive violation of fundamental human rights affecting the public at large.
The scale dictates the venue. The syllabus also highlights the concept of strict liability within tort law. We touched on this with product liability, but in general torts, it operates on a grander scale. If an entity engages in an inherently hazardous activity, say, operating a chemical manufacturing plant, they are liable for any injuries to the public if that hazard escapes, regardless of how careful they were.
It's the absolute assumption of risk. The text notes, the basis of such liability is the foreseeable risk inherent in the very nature of such activity. If you build a reservoir of toxic sludge and an unprecedented, unpredictable earthquake cracks the tank and poisons a village, you can't argue, well, we built the tank to code, it was an act of God. The law says you chose to collect the toxic sludge. You pay for the damage.
It doesn't matter if there was zero negligence. The liability is strict. But the absolute centerpiece of this final section, and arguably the most debated topic in modern jurisprudence, is the distinction between civil negligence and criminal negligence. And this debate reaches its absolute apex in the realm of medical negligence.
This is incredibly heavy territory. We have all heard horrific stories. A surgeon leaves a sponge inside a patient, or an anesthesiologist administers the wrong dosage, resulting in severe brain damage or death. The family is devastated. They don't just want compensation from a consumer forum, they want the doctor in handcuffs. When does a doctor's mistake cross the line from a civil tort where insurance pays out a settlement to a criminal charge under Section 304A of the Indian Penal Code causing death by negligence?
To answer that, the Osmania syllabus directs us to the definitive, landmark Supreme Court ruling in Jacob Matthew v. State of Punjab. This judgment is not just a legal ruling, it is a profound philosophical treatise on the nature of human error.
Set the context for us.
The Supreme Court recognized a growing, alarming trend. With the rise of consumer awareness, families were routinely filing criminal police complaints against doctors alongside civil claims, using the threat of prison to force massive financial settlements. The court had to intervene and draw a definitive boundary.
The judgment begins by breaking down the very word negligence. It states that in forensic speech, negligence has three distinct meanings.
Yes. First, it describes a state of mind as opposed to intention. You didn't intend to hurt the patient, you were just careless. Second, it describes the careless conduct itself. And third, it describes the breach of a duty of care imposed by law.
Okay.
To prove civil negligence in a consumer forum, you only need three elements. The doctor owed you a duty of care, they breached that duty through an error or omission, and you suffered damage as a direct result.
Okay, so a surgeon operates on my knee. They make a careless incision and sever a nerve. I have a permanent limp. They owed me a duty, they breached it, I suffered damage. That is civil negligence. The consumer forum orders the hospital to pay me 50 lakh rupees in compensation. But the families in the Jacob Matthew case argued, negligence is negligence. If the doctor was negligent enough to owe millions in civil court, they should be criminally liable too. What is the jurisprudential difference?
The Supreme Court emphatically declared that there is a massive fundamental difference, and it hinges on the metric of measurement. In civil law, it is the amount of damages incurred that determines the extent of the liability. But in criminal law, the amount of damage is secondary. It is the degree of negligence that determines criminal liability.
Let me make sure I truly grasp that because it sounds counterintuitive. Are you saying that a doctor could make a tiny, understandable error, a momentary lapse in judgment during a chaotic 12-hour surgery that tragically results in the patient's death? The damage is maximum, is the loss of a human life. The civil compensation would be enormous, but because the degree of negligence was small, an honest mistake, it is not a crime.
You have grasped it perfectly. Criminal liability in democratic legal systems requires what is known as mens rea guilty mind. Now, in a negligence case, there's obviously no explicit intent to kill. If there was, it would just be murder. But to cross the threshold into criminal negligence, the carelessness must be so gross, so profound, that it transforms into recklessness.
The judgment cites Lord Atkin, stating that a simple lack of care incurring civil liability is not enough for criminal law. You need a very high degree of negligence.
The Supreme Court used incredibly specific language. They spoke of gross and culpable neglect. Criminal negligence is taking a hazard knowing that the hazard is of such a degree that injury is most likely imminent.
So it's the difference between a tired surgeon misreading a poorly printed lab result and prescribing the wrong antibiotic, which is a tragic civil error, versus a surgeon showing up to the operating room visibly intoxicated or attempting a complex neurosurgery they have absolutely zero training for.
Precisely. In the latter examples, the doctor is acting with total reckless indifference to the consequences. That introduces the element of criminality. The court then explored the deeper philosophy of blame. They quoted a profound sociological text, Errors, Medicine, and the Law, which states that in the case of tragic accidents, society has a tendency to confuse the reasonable person with the error-free person.
The tendency to confuse the reasonable person with the error-free person. That is an incredibly powerful insight. We demand perfection from medical professionals. But human beings, by their very nature, are fallible. Even the most highly trained, cautious, reasonable surgeon on the planet will eventually make a mistake.
And the Supreme Court argued that a mature society must tolerate honest human error, even when the outcomes are utterly devastating. Because if we indiscriminately prosecute medical professionals as criminals for simple mistakes, we cause catastrophic damage to society as a whole.
Let me push back on that. Why? Wouldn't the constant threat of going to prison make doctors hypersensitive and ultimately much more careful?
It doesn't make them careful. It makes them defensive. The court warned that if doctors operate under the constant fear that every misdiagnosis or surgical complication will lead to a criminal trial, it destroys the doctor-patient relationship. It creates an atmosphere of suspicious formality. The judgment quoted a historical ruling stating that the most favorable view of an accused medical professional's conduct must be taken because it would be most fatal to the efficiency of the medical profession if no one could administer medicine without a halter around his neck.
A halter around his neck, a hangman's noose. If a brilliant trauma surgeon is standing over an emergency room table and they know that attempting a high-risk experimental life-saving procedure could result in a manslaughter charge if it fails, they will simply refuse to operate. They will let the patient die naturally rather than risk prison.
Exactly. Or they will practice what is known as defensive medicine. If you come in with a mild headache, a doctor terrified of a criminal lawsuit won't just prescribe rest. They will order 5 different MRI scans, a spinal tap, and a week of observation just to legally cover themselves. This bankrupts the patient, clogs the hospital infrastructure, and destroys the healthcare system.
So the Supreme Court concluded that distinguishing between a tragic civil wrong requiring financial compensation and a gross criminal act requiring prison is essential for the survival of the medical field. Blame is a heavy weapon, and misusing it distorts reality. Therefore, the threshold for criminal medical negligence must remain exceptionally high.
It is a sobering, necessary balance. It demands absolute financial accountability through the consumer forums while reserving the trauma of the criminal justice system for true, reckless bad actors.
Wow. We have covered a truly immense landscape of law today. We started by defining who gets to step into the arena, seeing how the 2019 Consumer Protection Act adapted to the realities of e-commerce, Instagram scams, and multi-level marketing.
We explored the structural power of the system, how pecuniary jurisdiction filters cases, how EDOCAL digitizes the fight, and how mandatory mediation cells attempt to defuse conflicts before they explode into trials.
We looked at the profound payoff, how commissions aren't just limited to basic refunds, but can issue punitive damages to regulate corporate behavior, strike down abusive clauses in 50-page digital contracts, and dynamically calculate compensation to match shifting economic realities, like we saw in the Vinacana real estate case.
We climb the strict 30-day appellate ladder, understanding how the system polices itself through revisional jurisdiction, ensuring that final orders carry the exact same weight as a civil court decree.
We stared into the dark side of corporate liability, examining the chilling, escalating criminal penalties for adulterating food or broadcasting disparaging, misleading advertisement.
And finally, we navigated the incredibly sensitive philosophical boundary between civil compensation and criminal prison time, learning from the Jacob Matthew case why society must demand accountability without putting a halter around the necks of professionals acting in good faith.
It is a masterful, intricate system of checks, balances, and protections. It transforms the consumer from a helpless gear in the machine into a formidable legal entity. But as we wrap up this deep dive into the Osmania syllabus, I want to leave you with one final provocative thought. We spent the last hour marveling at how the 2019 Act updated the law for the digital era. We discussed the agonizing difficulty of holding a human doctor criminally liable for a negligent error. But technology is moving faster than the law ever could. We are rapidly entering an era of AI-driven services. We have automated algorithmic trading managing our life savings and machine learning diagnostics reading our MRI scans. So here's the question. As artificial intelligence begins to make the decisions that human professionals used to make, who do we hold responsible when an algorithm makes an error so egregious it constitutes gross negligence? If an AI diagnostic tool makes a reckless mistake that costs a human life, does the hospital face a civil consumer forum complaint? Or does the lead software engineer face a criminal court for manslaughter? How does the philosophy of tolerating honest human error apply to a machine that was programmed not to make mistakes?
It is the next great frontier of legal philosophy. The line between product liability, civil negligence, and criminal recklessness is about to be tested in ways the drafters of the 2019 Act couldn't possibly imagine, and the courts will have to find an answer.
Something to ponder the next time you interact with an automated customer service bot or read an AI-generated medical summary. Thank you for joining us on this exhaustive deep dive. We hope you walk away viewing every purchase, every service agreement, and every click of "I agree" through the newly empowered lens of the law.